Okay. Welcome, everyone. I'm going to get started. I am Jodi Daniels, CEO and privacy consultant at Red Clover Advisors, and we're so glad that you have joined us here today for our webinar, Ad Tech in the Accountability Era. And I have brought some amazing experts to be able to join our conversation here today. So, just real briefly, if you're not familiar with Red Clover Advisors, we are privacy consultants. We're all about operationalizing the long list of privacy requirements and helping you tackle the long list of to-dos that you might have. And I'm so excited to be joined by Kamy and Taylor today. So, Kamy, can you go ahead and introduce yourself?
Absolutely. Thank you so much. My name is Kamy Ahmadian. I'm a partner at Baker Hostetler in the Los Angeles office. I am a litigator. For the last 10 years, my practice has focused on consumer class actions and complex commercial litigation. Prior to that, I clerked for John Houston down in the Southern District of California. And for better or for worse, the last 2 to 3 years, the bulk of my cases have been and SIPA related. I've litigated, settled, arbitrated, I think well over 150 SIPA cases over the last few years. So, and they're very much still coming as we'll discuss. So excited to be here today. I apologize, I'm a little under the weather, so if I have um, to take my video, self-off video real quick, to cough or sneeze. You don't need to see that, but I wouldn't miss talking about SIPA and SIPA litigation for the world. So happy to be here.
We love the passion. I mean, look at how much fun we're going to have today, people.
Yeah,
Okay.
love
So
it.
thank you so much, Kami. We're really excited that you're here. Taylor, can you share more about yourself and practice?
Yes. Hi, everyone. My name's Taylor Bloom, and I'm a partner in Baker Hostetler's Orange County office. I am in the privacy governance group, which means I'm a privacy compliance attorney. So, day in and day out, I'm advising companies on everything related to privacy compliance, state privacy laws, and all the implications that come with that. I also represent companies in investigations with Attorney General, state inquiries, and everything in that realm. A lot of my practice is ad tech focused. And as we will talk about in this webinar, a lot of the enforcement and scrutiny we see from the state regulators is related to ad tech and opt-outs, which I'm very excited to talk about today.
Well, welcome to both of you. And some of you have already found our Q&A button. And I have to laugh at one participant who booed SIPA. So you might have some company with that here. I'm sure we'll talk a little bit more about it today. If you do have questions, please put them in the Q&A. Should be at the bottom of your screen. We are always asked, is this going to be recorded? And yes, it will be recorded. So that recording will come out in the next day or so. What are we going to be talking about today? Well, I gave you a little bit of a hint. We're going to be talking about enforcement patterns that are emerging across state regulators. We're going to talk about operational mistakes that we see in these ad tech ecosystems and how to solve them, litigation exposure, and what is happening on those wiretap cases, how investigations are scrutinizing actual real data flows, the vendor relationships, and downstream disclosures. It will be very important to understand what you have on your site and what is actually happening, which brings us to what accountability really looks like, and again, the Q&A. So before we get started, we're going to launch a poll question because what kind of webinar would this be if we didn't have a poll? All right. So with that being said, our question today is, what's driving your organization to focus on ad tech accountability right now? Are you preparing for evolving regulatory expectations, managing risk from ad tech tools and systems, building trust and transparency with customers, managing litigation risk? You might want to pick all of them. I'm sorry, you have to pick your favorite. That's the way this works. A couple more people are getting their vote in. Which one? All right, you get 5 more seconds to answer. And for anyone curious, I have no idea what you vote, by the way. In case people don't vote from a privacy standpoint, we don't know. All we get is what I share over here. So just in case that was discouraging anyone from participating in Zoom polls, the Zoom people we can't see it. All right. So with that, I'm going to end the poll and share the results. 52%, so half of you, are trying to manage risk from ag tech tools and systems as your major focus, followed by preparing for evolving regulatory expectations, then building trust and transparency with customers, and managing litigation risk. So while litigation is really important, I am excited that trust and transparency is above the litigation risk. I do think that's such an important piece of privacy programs. But unfortunately, litigation is here and real. And so let's get into that because I see three big themes in the landscape today. We have privacy laws, a myriad of state. You might be a global organization and you're having to think about GDPR, Canada, Mexico, Brazil, China, all across the globe, as well as the state laws. And depending on the industry you're in, you also might have to be thinking about sensitive data or age of your consumer base. So there's a lot on the privacy law front. And just in the time period we've been talking about hosting this webinar, we have two new privacy laws that have come about. We've been planning this for a while. We were at 19. Poof, we blinked, and here we are. We're at 21. And Taylor is going to dive deep into the enforcement actions and what are the themes that we should be learning. And then our good old friend picks the litigation that we know some of you are very, very excited to hear all about. So with that, let's just get into it. Taylor, why don't you kick us off with what are the recurring themes that we keep seeing in enforcement?
So first and foremost, opt-outs continue to be the theme of enforcements. Obviously, we see a few other issues coming out, but the main prominent recurring theme is opt-outs. And there's a few things that we keep seeing companies get dinged for over and over again. So, number one, that the opt-out option wasn't easy to execute or was hard to find, which means, it could have taken multiple steps. That could mean when you went to fill out a form to opt out of non-cookie based types of, sales sharing, target advertising, you required too much information or required too many steps. The next piece is more than minimal steps. So, it should be, 4 steps to, opt out and 1 step to opt in. You need to have symmetry in your opt out process. And then really important, having confusing or dark patterns in your opt out preference system and anything in your choice architecture of not being clear and concise in how you communicate these things to consumers. Another big one we've seen, one of these was in the Todd Snyder case, is requiring identity verification or unnecessary data in the opt-out process. I mentioned that a little bit before, but the identity verification was an issue in the Todd Snyder case, and then requiring unnecessary data was an issue that brought up in Honda. But we do continue to see these same patterns over and over again. Another big one is the opt-out doesn't function as represented, which means you exercised a choice and the data continued to still be shared with third parties. So even if you have everything set up, if it doesn't actually work, it's not doing anything. And that's something that we're going to talk about a lot today is testing and retesting and actually ensuring that your systems are working and that you're checking for changes and new vendors and new tools and making sure that downstream data flow is actually effectuating the choices consumers think they're making. And then failing to honor GPC signals. So, if a consumer lands on your website and they have their GPC signal on, you need to ensure that that is recognized and ingested as an opt-out. And then, one of the most recent cases in Disney was that the opt-out doesn't apply across services, tracking technologies, or offline data. So, if you are able to connect a consumer across various interfaces and user experiences, then the CPPA has found that you have an obligation to do so and that your opt-out should carry over.
Awesome. Thank you. And
And this is one of my favorite quotes from our recent Disney settlement is that, an effective opt-out is truly one of the bare necessities of complying with the CCPA. They've made it super clear that opt-outs is this is just the bare minimum. There's so much more to the law that's required, but if your opt-out doesn't work, that is just literally the lowest hanging fruit on their plate to come and make sure that you are, investigated and an inquiry is opened and what can lead to, a settlement such as this. So here in this case for Disney, they found that there were gaps that allowed Disney to continue to sell and share consumers' data, regardless of them exercising an opt-out. And then similarly in Todd Snyder, the regulators were talking about that even if you have a privacy management solution, and just because you have that platform in place, that doesn't mean you're off the hook for compliance. You actually have to make sure that the system works. It's been configured properly. You're not just using an off-the-shelf configuration that doesn't take into account how your business operates or what best practices are. A lot of the off-the-shelf implementations are not actually aligned with the requirements in the US. And so it's really important that, as a business, you're evaluating how you implement these solutions, the actual phrasing that you put in them, and then how it's working. There's a lot more to this, but I think this last quote from Michael Macco here of using a consent management platform doesn't get you off the hook for compliance, I think is really important to understand and recognize, and why all of this testing, having legal counsel, having consultants, and having so many different players involved here is so important.
I really want to echo. I love how you mentioned it's the collective team,
Mhm.
having legal counsel and someone who is able to configure the tool, whether that's internal or external. It's really very, very important. So I just wanted to echo that for sure. Which brings us to the battle that I see all the time. And in particular, just a couple weeks ago, many of you might have even been at IAPP, and some of you might have participated in the IAB Public Policy and Legal Summit. This right here was a hot topic almost all day long. And to to help us sort through this topic, let's understand a little bit of the current SIPA scene. So, Kami, help us understand what is happening with SIPA.
Sure. So, and just a real quick history of SIPA to the extent that you're not familiar. Um, about 2 to 3 years ago, Plaintiffs' Counsel began using SIPA and the wiretapping portion of SIPA 631A. Um, again, a statute that was drafted in the 1960s to start bringing claims against companies' websites who had chatbot features. Essentially, the claim was, I visited your website. You're using a third-party chatbot to operate. You're using a third-party company to operate your chatbot. I intended to communicate with you, company, and that information, that communication went to this third party who's operating the chat feature. Um, they quickly pivoted, as plaintiffs' attorneys typically do, to essentially any cookie or pixel, any information that's sent to a third party constitutes an illegal wiretap. Um, so these they started running into some hesitant judges with the wiretapping claims because you have to show that it's a communication, and sometimes when you visit a website, you don't actually communicate with the website in any way. You just click some buttons. And also you have to show real-time interception, um, that someone read or attempted to read in real time that communication. That was proving to be a little bit of there was a little difficulty there. So again, they pivoted. So the newer litigation wave and trend under SIPA is under the pen register and trap and trace provisions, which is 638.52. Historically, pen registers and trap and trace devices, if you think about them, they're used by law enforcement. They're put on a phone line, and this gives the law enforcement a way to identify who's calling in, who's calling out. Just the numbers. There's no content at all. Um, so plaintiffs' counsel have been effective in convincing judges and using the very broad definition of uh, pen registers and trap and trace device, um, that that basically internet technology, cookies and pixels, can constitute a pen register or trap and trace device. Um, so again, that's the current flavor of the month. They could pivot soon for sure. Um, I think it's important to realize why these SIPA claims are so attractive to plaintiffs' attorneys, and it's statutory damages. They can use the threat of statutory damages, which is $5,000 per violation, which they've argued is per visitor. And you can imagine a website in California that has thousands and thousands of visitors every day. That can certainly add up. Um, so I think the frustrating part, and Jodi mentioned it prior to the slide, is the interplay between SIPA and the CCPA. And that's typically the first question I get when I have a client that's dealing with a SIPA claim for the first time is, well, I'm complying with CCPA. Isn't that enough? And unfortunately, it's not enough to prevent these type of lawsuits. We've certainly made that argument that, uh, an enormous amount of resources and time and rulemaking, you know, processes went into the CCPA. You have, that were carefully defines how businesses can lawfully use third-party cookies on their websites, and then somehow we're letting a decades-old wiretapping statute in SIPA that says nothing about cookies, nothing about pixels, nothing about internet technology whatsoever. That was, in terms of the wiretapping portion, was drafted well in advance of when the internet was even formed, and we're allowing that to essentially bypass the CCPA. And unfortunately, judges are allowing that to happen. Um, they are the legislative intent of CCPA is being bypassed with SIPA, and that's frustrating. I will say, so that's the interplay between CCPA and SIPA. Where do we currently stand with SIPA litigation? I would say we're still very much split. Courts are split 50-50. You can kind of flip a coin, and whoever you get assigned to, they probably had a SIPA case, and you can tell very quickly if they're going to kind of green light that case and allow it to get past the motion to dismiss or demur, or if they're going to dismiss it. Um, Luckily, we've had some pretty good decisions recently in the federal courts, in the Ninth Circuit with POPA, v. Microsoft. Essentially, those arise out of standing challenges. So it's less helpful in state court, but certainly in federal court, they've been helpful. The Ninth Circuit kind of reiterated, okay, just because certain information was intercepted is not enough to give rise to a concrete injury. You have to look at what that information is. If it's not sensitive, or it's not, if it's just your basic device, browser, operating system, mouse movements, that's not a privacy injury. So it has to be embarrassing, invasive, or private information. So that's been very helpful. Some courts have gotten around POPA, but we've had some success. And similarly in the Third Circuit with Cook versus GameStop. Um, Hopefully we'll have some clarity soon. So there's a case that's in the California Court of Appeals, Variety Media. It will address whether 638.51, so the trap and trace provision, applies to web tracking technology. Um, this will be the first appellate issue, or appellate decision on this issue. That said, it's California Appellate Court, so it's going to take some time, maybe a year. So if you currently have a state court case, you can consider whether you stay pending that decision, because it could obviously be very favorable. And then we have SB 690, which is a California bill that was passed in the Senate last year. And it's amending SIPA to include a commercial purpose exception, essentially trying to stop these lawsuits. It's unfortunately stalled in the assembly, and put on a 2-year track. So it's going to be brought up again in 2026, later 2026. So if it's passed, it unfortunately won't go into effect until 2027. And they took out the retroactive provision, so it'll just be for future claims. But there is seemingly some light at the end of the tunnel. So that is the high level SIPA litigation recap.
I'm curious, one of the questions I see companies have is it just California wiretapping that I have to worry about? Can you talk maybe just briefly on, are you seeing this in other states, and are there other states kind of as prevalent as California?
I think the only other one that's as prevalent is Pennsylvania. They have Wesca. I don't think they've popped up occasionally. We've seen some in Arizona, um, some in Washington, but California is certainly your primary wiretapping, location. But Pennsylvania as well with Wesca. Those are the main two.
And then what the other question I have for you that I receive a lot is what about types of pixels? Are there some more than others that might spark a letter or an inquiry, or are they all created equal?
I think there was a wave over the last year that the TikTok pixel was very hot and sexy given the government investigations and they were using we were clients were receiving a lot of demand letters with quotes from the government hearings on TikTok about how they are feeding information to the Chinese government and so that one was very I think they were it was more attractive to plaintiffs' attorneys because there was a heightened risk that your information was going to a potential bad actor. I think ultimately it doesn't really matter. Um, I think all of them are created equal. Um, I think right now social media, TikTok are probably the most attractive for plaintiffs' attorneys to add to their letter.
Thank you so much.
Hmm.
Next, we were going to go into operational best practices. We do have a question that, Taylor, I would love to ask you now because it's kind of tied to the settlements and enforcement, and I feel like it might be a nice way to round out, which is, and of course, however much you can answer, what is the takeaway from the Jam City settlement where California said opt-outs must be cross-device effective, even if the only personal information data collected is user device? Any thoughts on that question?
I think there's a good amount to break down there, but I think the takeaway is if you're able to recognize that user on another device, then you need to be able to carry that opt-out over. So if you can only recognize them on that one device, then you would have an argument that that is where the opt-out needs to be effective. But if you were able to recognize them, like they have a login on web and they have a login on mobile, and they opted out on their mobile, then you would need to recognize that over to web. And so if you have the ability to recognize them across devices, then you have an obligation to recognize that opt-out across as well.
I appreciate you answering even on our non-Q&A slide. So the big question that we wanted to start with is, are cookie banners required? And obviously, when we're talking about cookie banners, we really are talking about digital tracking. People are synonymous with cookies. So most of this still has cookies, but we do get that it's the broader technology. Um, Globally, EU, UK, many other global countries, it's typically an opt-in. And Taylor, I love seeing your head nodding because in the US, it depends. So I'm gonna throw it over to both of you to share your thoughts on what do we what should companies be considering if they're in the US?
Yes, and we talk about this together a lot, and I bring Kamy into calls all the time with clients when we're talking about this because in the US, generally speaking, let's take out sensitive data, children's data. Let's just talk about your general run-of-the-mill website. There is no legal obligation to have a cookie banner. However, there are some benefits to having a cookie banner, and a big benefit of that can be mitigating potential litigation risk. Another benefit, can be that you were trying to get people on notice of your terms of use and you want your dispute resolution provisions to be taken into consideration. You want an argument that a user assented to those dispute resolution provisions. Hard to do that just having a terms of use link buried in the footer of your website. a lot easier to make that argument when you have a website cookie banner that pops up and explains that you use cookies and tracking technologies for various purposes like advertising and analytics, and you share the data collected with those providers. You share the data you collect with those third parties. And by continuing to use this website, you are aware and acknowledge these practices and also agree to the website terms of use. And you can do things like not having the cookies fire until the user takes an affirmative action to continue to the site. And I'll obviously let Kami jump in here, but I think it's hard to make an argument the user wasn't aware of what was going on. The user didn't take an affirmative action before the cookies fired. And as such, those terms of use are going to come into play as to the best of our ability. But it's really hard to say, I didn't know those cookies were going to fire, or I didn't know you were going to share my data with third parties, or I didn't know you had, a class action waiver and those terms of use when you literally put them on notice of all of those things and they had to take an action before anything else could occur. I could talk about this all day, but I'll let Kami chime in too because we this is something
Yeah.
we often talk
Yeah,
about.
so two things I would note on the litigation risk with cookie banners. I would say first, and I hate to be always the Debbie Downer when it comes to litigation risk, but with these SIPA claims, um, a cookie banner certainly helps, but it's not going to be a fix-all to prevent these type of claims. A lot of these attorneys, plaintiffs' attorneys, are making the argument that even if you have a cookie banner, because a cookie fired before, right when I visited the website, before I had even a chance to look at your cookie banner, it's a SIPA violation. It's a wiretapping, it's a trap and trace violation. Uh, so I think in some instances, depending obviously on your marketing team and whether this is something that will dramatically affect the benefits that you receive from these type of cookies. If you delay any type of interaction, or any type of cookies or pixels dropping to allow a person to review the cookie banner, that is a huge that will help prevent some litigation. And some attorneys will go away if you can establish that. The second part of it is we've seen that adding a cookie banner it also adds potential litigation risk. Cookie banners can be a little well, early on, I think they're getting better, but they can be a little finicky and they don't work all the time. And we have had a slew of class actions that are settling and resolving and litigating at a much higher rate, well above six figures for a lot of them, as opposed to, your low level settlements for the SIPA violations. And those claims are based on I visited your website, I clicked, I rejected certain cookies. I then continued to use your website thinking, oh, I'm not, those cookies are not going to fire. And they still did. And so they bring the same SIPA claims, but they also bring misrepresentation claims, invasion of privacy claims. And so there is an additional risk that if you didn't have a cookie banner at all, which, as Taylor said, you don't have to, that you would not be, subject to that risk. So that is, those are two, again, not to be the Debbie Downer, but two additional risks that arise through use of a cookie banner.
And one of the things we talk about a lot is so you don't have to do a cookie banner. If you're going to do it, you need to do it right.
Absolutely.
And you need to understand that if you don't do it right, you're opening yourself up to more litigation. Because just like Kami was saying, so you have a cookie banner that says, you know, to opt into cookies, to press accept, or, it tells you some instructions there. But the second you landed on that site, those cookies are already fired. Now you've made a false and deceptive statement. And that is just one easy hook for them to, start looking at you closer. But if your cookie banner makes some type of representation that, you have a choice to opt in before cookies would fire, but the cookies fire the second you land, you're already in hot water.
Yeah. And I've noticed the there have been more letters coming out with that claim. It was typically just one firm that was bringing these class actions. I think this cookie banner deceptive statement is probably going to be the new wave, so it's something to consider. Um, when you are thinking about adding a cookie banner.
I think that crystal ball view is really helpful of what might be the next wave of focus for these people because it seems like it started with session replay cookies. Then it sounds like we went to TikTok. Now we're on to the rest of social media. Now we might be focusing on the language. I don't know what will happen next year. It'll be interesting to see. But with that being said, let's also talk about there's other considerations. We have our banner or no banner. We just discussed that. And Taylor, in the enforcement trends, you talked about global privacy control. And we often see that there are still companies who don't know what global privacy control is or think if I just press the button in the cookie consent software that it's supposed to work. And I appreciate that that's actually what you would think is it's a button and you press it and poof, it's supposed to work. It doesn't actually work that way. There's some setup behind the scenes to actually make global privacy control work. And so maybe we can kind of walk through each of these. Taylor, anything that you would want to add on global privacy control and maybe also the your privacy choices, because I know there's lots of thoughts of how to use that logo properly.
Yes. So GPC, I think there is quite a bit of confusion that, it doesn't actually take website development work. That is not true. Your website developers need to be involved. There is actual website development work involved in making sure that you are ingesting that signal and it is interacting with your consent preference center. There's also the new California requirement that came into effect earlier this year that requires you to dynamically display when a GPC signal has been recognized. And so I think that's another really important one. There's also, a lot of configuration complexities that need to be taken into account around signal recognition. And we see confusion in the various preference centers of, which signal is recognized and what to do when a signal is being overridden by a GPC signal. And so really important that you're thinking about these things and not just thinking that, oh, because you checked a box within your consent preference center configuration that all of a sudden your website's compliant and GPC is being recognized. There's much more to it. And you do need to make sure that you are also, following the California CCPA regulations around showing consumers when their GPC signal is recognized. Um, Another one, your privacy choices. Uh, I you would think at this point it's super clear, but we do still see confusion around this. Of I see websites all the time where you go and look in the footer and it says my privacy choices or privacy preferences, but then it'll have the logo. The CPPA has made it very clear that this is a prescriptive requirement. You're either using the do not sell or share my personal information link or the your privacy choices link, and in addition, having the logo. You can't have one without the other. You have to have the logo and your privacy choices together. You can't make it really, really small and hard to find. It needs to be the same size as your other footer links. And you need to ensure that it is either taking someone to a place where they can exercise their choices or it's opening up their preference center, one or the other. Uh, I think those are probably my main takeaways on those two topics.
Yeah, no, that makes I see a lot of as well, just do not sell.
Yeah.
But just like we don't want to have the rest of the information that is there or it's hidden, you can't find it, or the font is different, the size is different. It is equal here, people. But also disclosures. Do not forget your privacy notice. If there's a cookie policy, that cookie policy needs to mirror what's actually happening and what your choices are. And don't forget to update that. And sometimes the people who are doing the consent software are not the same people who are doing these disclosures. And if you have one group not talking to the other, you get disjointed and outdated information, which does not help anybody. There's so many other areas, but then also contracts as well, which is if I have a pixel on my site, do I have a contract with them? And this has shown up a couple different times in some of the enforcement actions that we've seen. They didn't have the contract in place, or the contract didn't have all of the proper provisions that were there. And Taylor, I don't know if you want to add anything else to that contract piece as well.
No, I just think it's a really important consideration. It's been a focus we've seen in a lot of investigations. It's one thing I remind clients of all the time is how important this is, that any tracking tech that's firing on your website, that if Post opt-out, if those cookies are still firing, you're going to need to be able to show evidence that you have a service provider or processor contract in place. And it's one of the first things we hear from regulators when they say, hey, it looks like your opt-out's not working. Did you have a service provider slash processor contract in place with that vendor? And that is why we continue to see that tracking technology firing on your website post opt-out. If not, it appears you're not appropriately effectuating opt-outs. And then from a California perspective, ensure you also have third-party contracts in place as well.
Excellent points. Contracts are important. Contracts, contracts, contracts. We could talk about that all day, but we won't. Let's move on to categories because there are also a lot of thoughts around categories. These are the common categories we see. We see other people make, different names for them. Sometimes we see analytics instead of performance. Sometimes we see it's advertising, but in general, these are the common categories that we see here. And you definitely need your categorization when you are global. You need that strictly necessary and the other kinds of categories that are here. In the US, we don't necessarily have these same categories. And I know Taylor and Kama, you might even have some real strong thoughts that we want to be able to inform our audience of.
I feel super strongly that these categories can be confusing in the US. I think in the EU, it's a very different landscape we're navigating under. But in the US, there is no concept of strictly necessary. There is a concept that if someone is a processor not engaging in targeted advertising, then you would not have to write an opt-out, or you are a service provider, then you would not have to write an opt-out. But it is not a concept that solely because you are strictly necessary, you don't need the correct contractual provisions in place. That is not true in the US. And so I do not like using the categories of strictly necessary because it's not true. Some of these providers that you're not allowing an opt out for aren't strictly necessary. It could be a first party analytics tool that is only providing data to you. That's not strictly necessary, but it's going to continue to fire because you have a service provider contract in place, but you've said you can't opt out of it. Now there's all these different pitfalls where you can make false and deceptive statements, and plaintiffs attorneys will jump on anything. And so any angles here of you can't opt out of strictly necessary, well, that cookie's not strictly necessary, and I can't opt out of that. Now you've made a statement that's not true. The other things that I get concerned around are the concepts of performance targeting social media. You can totally use those categories, but our obligations in the US are to allow consumers to opt out of tracking tech that constitutes sales, sharing, and targeted advertising. So unless you're being super, super clear and stating to opt out of tracking tech that constitutes sales, sharing, and targeted advertising, you will need to take choices and, toggle the various toggles below to opt out. You can run into pitfalls. But where I get concerned is also you're making someone, make all these different choices to do an opt out. But what I'd prefer to have is one toggle that is opt out of sales, sharing, and targeted advertising. Give one clear, concise choice here, I think is generally the best bet.
Kami, I see you nodding your head. Please share.
Yeah, no, I echo everything Taylor just said. I think for the cookie banner litigation that we've seen, they love to nitpick cookies that are in strictly necessary and say these are, this is not a strictly necessary cookie. You do not need this to operate your website. So to limit it just to make it as clear as possible and limit it just to one particular category that you are allowing your website visitor to opt out is the best approach. Keeping it very, very clear and not giving some impression that these particular cookies are absolutely necessary to the operation of your website because they're going to nitpick that and they're going to still bring those claims if they dispute or have some expert that can opine that that's not a necessary cookie.
And in talking about cookie banners, this is just an example because what we were talking about here in what's important that we want to call out, we have allow all at the top, we have reject all at the bottom. There's a lot of, and then we have the exact categories that we just discussed over here. In our little scenario, they're all off. But there's also this idea of, well, I can't really reject all cookies because I'm like stuck with these cookies up here. And I know there's a variety of ways of how to kind of set this piece up. And this is the preference center part. So we've moved past a banner. I'm in a preference center. So, Taylor and Kame, your opinions on what people should be considering when they're working on this tab or this piece right here.
In the US, I'd prefer one toggle. I want to make this as simple and clear and concise to consumers as possible. And for a disconcerting consumer, our legal obligations are to allow the opt-outs of sales sharing target advertising. And so what I like is one toggle. I want that strictly necessary hidden. I don't want four other choices here and making them take four separate actions. I want them to have one toggle where they can choose to opt out of what they're legally obligated to opt out of.
Kame, what would you add?
Yeah, I mean, I just think looking at this and putting my plaintiff's attorney hat on, having a button that says reject all is, potentially deceptive. You can't reject all cookies. There's strictly necessary cookies that are active. And, obviously we could make the argument that it says there that it's always active, but, they're always going to be able to potentially make that argument and bring that case. And so I think keeping it very streamlined, very clear, having one toggle, like Taylor said, is the best approach.
And just chiming in one more, I know we've said this, but it's not rejecting all, it's only rejecting what you've categorized as a service provider or processor not engaged in targeted advertising.
Right.
And so, unless you have this super long button that is reject non-processor targeted advertising or service, accept those, and you clarified that exact thing and had a call out, which I think is even more confusing to consumers, then it truly is a false statement. You're not rejecting all. You're only rejecting the cookies that you've not categorized that are truly third parties. And so unless you're going to go through and explain that those nuances to a consumer, which could be really confusing, then you're just bucking yourself into potential more risk.
And on the global side, I want to remind
The
people
opposite, yes,
if you have
sorry.
accept, you have to like reject
You
is
have
its
to.
best friend.
Yeah.
But I do believe also in the optional part because I can't actually reject all because I have my
Mhm.
strictly necessary that might
Yep.
be up here. So making sure you're thinking about your jurisdictions and where you are and what is actually happening there. Now, I want to pause for just a moment and let's do another poll because we've all been listening for a little while and we've been talking about kind of ad tech ecosystem and pixels and cookies. So I'm kind of curious, what is the greatest risk in your ad tech ecosystem today? Is it incomplete visibility into data flows across platforms, over reliance on consent management platforms for compliance, which we've been talking about? Is it the vendor and third party tracking practices? We talked a little bit about contracts. Or how about gaps in notices and disclosures tied to ad tech? So vote, 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 vote. We have some leading winners happening over here. All right, gonna close the poll. Share what we got. So 44% of you are concerned with number one, incomplete visibility into data flows across platforms. And I think that's a really important one to be able to lock down. It makes complying with any of these laws really challenging if you have poor visibility into what's actually happening. But then you're also really worried about what is happening with those vendors and third parties, followed by over-reliance on consent platforms, and just a handful of you are concerned in the gap in notice and disclosures. That small group of you, I'm going to presume, have a really great handle on how the disclosures are. So if you don't think that is a true statement, then I'm going to make you increase the gap or increase and make sure that you're familiar with the disclosures happening so that it really does mirror, because then otherwise you have a whole nother problem. So here, we just wanted to spend a few minutes talking a little bit about some kind of cookie banner do's and don'ts. And we sort of hinted before on the prior page with our preference center that it really does matter if you're trying to focus US versus EU, because globally, you're going to want to be able to list those cookies used so that you can put them in their appropriate categories. You want to think about the mobile experience. I see often that you have something designed for desktop and just kind of plop it on mobile without realizing that your mobile experience is truly different. And it is important to think about all the different devices that your people and your consumers are using. And so be really mindful that you're not blocking everything. I can't read I've seen things have been cut off. I can't even read the consent banner because the whole experience has been Just not good. Making sure that you're explaining what your consent options are. We kind of talked about accepting cookies. I want to talk about that for a moment because if people wanted to have a notice, maybe Taylor and Kami, you can talk a little bit about kind of the SIPA-like notices, and is it an accept the cookies or just acknowledgement that they're here? Because when I'm saying here, don't force someone to accept the cookies, I'm very much thinking from a global standpoint, but we also want to make sure we're balancing the choices that are here, and the rest is sort of self-explanatory.
I think it depends on what your strategy is. So if you're willing to take an opt-in approach because you really want to reduce potential litigation exposure and you want to make it super clear that these cookies aren't going to fire until you take an affirmative action, great, you can totally do that. It's, I think, in my perspective, and Colin can, chime in too, that that's going to reduce your litigation risk. But if you're not intending to do an opt-in approach, then you need to be super careful in your phrasing of not giving any false impressions that cookies aren't going to fire until you do something when they actually indeed fire the second you land on the website. Majority of my clients don't want to take an opt-in approach in the US because they're not legally required to. And so what they're doing is they're balancing the potential litigation risk with the business impact. And that's a business risk qualification. You have to balance that. Is the potential cost of these various litigation claims, does that outweigh the business impact or not? And I'd say for a lot of my clients, they haven't came to the point where they think it actually outweighs it. That doing an opt-in approach impacts their analytics and their remarketing and all their campaigns so extensively that they don't want to do an opt-in approach. But sometimes they do want to say, okay, well, let's at least do a cookie banner. So at least we can claim we put people on notice. Kami is going to very clearly, and I will echo this, that's not going to reduce, that's not going to get rid of litigation. It gives you a better angle to say we put people on notice and we try, we put them on notice of our website terms as well, and at least try to maybe have an argument that our website terms of use come into play. At least gives you a fighting, some semblance of a fighting chance there. But it's really the worst case scenario is to give the impression that a consumer can make a choice, but it's a false choice. So that I think that's like the biggest pitfall there. And so if you're going to do it, you just have to be really clear and concise as to what you're doing and why. But I think one of the biggest ones we see all the time is, it gives this false impression that cookies aren't firing until you take an action, but that's not true.
Right. Right. And I think I would echo the point, and we bring this up with clients all the time, is having that conversation with their business team, and, you know, doing a quick cookie pixel hygiene check. Which ones are you using? What are you benefiting from them? If you're, if the benefit you're getting from them is just enormous and bringing in significant either, business or, some intelligence that you're using to generate business, then the SIPA risk in comparison is typically low. And so the recommendation is, fight these when they come up, or settle them for, a quick settlement. They're annoying and it feels gross to pay them out sometimes, but you're weighing that business risk, or you're weighing that litigation risk against a significant benefit you're getting from the cookies. And so that's always a conversation you have to have. Um, and we've seen, you know, kind of a in between a full-on cookie banner opt out approach is just like a cookie notice banner that pops up, doesn't allow them to opt out of anything, but makes it very clear that we're using cookies. By continuing to use the website, you agree or you acknowledge that cookies are firing. And to Taylor's point, that's not going to fully prevent SIPA litigation unless you have it set up in such a way that nothing fires until someone interacts with that, either clicks away or clicks OK. But again, some marketing teams don't like that. You might get a visitor that just leaves, or it might impact the data that they're receiving. So those are some considerations as well.
Amazing feedback. I have blinked and oh my goodness, it is 50 minutes in. And so we have a few other areas that I think we just want to highlight and make sure that people are thinking about. So dark patterns, we've kind of talked a lot about dark patterns sort of already, but as a friendly reminder, making sure that you don't have big tests that is hinting at me, pick me. We don't want that. The borders, the text, the size, unequal options, like constantly accept. I've seen those as well in a very dark pattern type of way. We have emphasized testing. Taylor shared a few examples where you thought it worked, but actually it didn't. So this is really important. Set it up, work with the web team, the development team. They need to be a part of this. And depending on how much ad tech you have on the site, might determine how involved they need to be. Do you have a tag manager? What else is actually happening on that page? But you really want to test. And if you opt out, it needs to not fire. If you have GPC, it needs to listen. If you have do not sell, it needs to follow what we talked about earlier on in the enforcement. And then I have never seen a website that is not dynamic and something changes. And sometimes they're changing something on the website that has absolutely nothing to do with privacy, but it breaks your privacy piece. So if you don't have anything in place to be able to catch that, then you're going to think it worked because you tested it when you put it on, but then these other people did things and now it doesn't work anymore. So either have a ongoing method. There are a variety of tools these days. Some of the actual consent manager tools are trying to flag this for you. There are third-party tools that will audit this for you. This is actually a really big area that I see just as a total miss.
Yeah. And can I add just one thing on the testing?
Absolutely.
So from a class action litigator perspective, testing is very important because if you have a good testing program, look, things are going to break. Technology is constantly changing. Things aren't going to always work perfectly. But if you have a potential class action and the plaintiff's attorney is bringing claims, and you can go to them and say, yeah, it was broken, but it was broken for 2 days or 2 weeks. So your class size and class period is going to be very, very small. That's a huge, potential argument, and to get them to go away and, not see dollar signs. And so if you don't have that where it was potentially broken for months or a year, um, that's obviously a very different story. So testing is huge in terms of preventing, even if you get a lawsuit and getting it settled for much cheaper, um, or limiting that class liability.
That is such an important tidbit and nugget and gold of information. I hope everyone heard that. Really, really valuable.
Sorry, one other last piece there. The other big part of testing and like checking your scans is in a lot of these platforms, if you have cookies that show up in the unknown category, you can't actually effectuate an opt-out. So unless you're ensuring that you're checking these reports and making sure they're accurate, you could have cookies that actually the opt-out isn't effective.
Excellent point. And here we've been talking about you need to have a variety of teams like your web development team, your marketing team, privacy, legal. That might be internal, that might be external. You might need your IT teams, whoever's responsible for your consent. And please don't forget about the agency. A lot of times people say, oh, I outsourced it to the agency. They're covered. Nope, that's actually you. See, the letter comes to you, the consumers come to you, the enforcement action comes to you. It doesn't go to the agency. You are responsible for managing the agency or whoever else actually places anything on your site. And you'll want to make sure that you have a solid process for that. Uh, Taylor, do you just want to highlight maybe just very briefly, some of the other areas that we haven't yet covered of where these pixels impact?
Yeah, so certain tracking technologies could require different considerations, and certain websites have different considerations. So if you are a website that is targeted towards minors in certain states, depending on the age of your audience, in some states, if you're under the age of 18, deploying tracking tech that is constituting sales, sharing, or target advertising could require opt-in consent. So while the general rule in the US is that it is an opt-out regime, that is not a 100% rule. There are always nuances to that depending on what you're doing. If you're on a site where sensitive data is being collected, that could also require consent. If you have, tracking tech on pages where that data flow is capturing, data that's input into a web form, and there's sensitive data on that web form, and that's getting, transmitted to a third party. There's additional considerations. Uh, Also, privacy risk assessments. If you're engaging in tracking tech that constitutes sales, sharing, targeted advertising, you are going to have legal obligations to be undergoing risk assessments. And, while we've had those obligations in place for various states, the updated, finalized CCPA regs added a lot of nuances and additional requirements that don't exist across the other states. So making sure that you have updated privacy risk assessments that assess your use of these various tracking technologies are super important. Making sure your website privacy notices. Sometimes you have contractual obligations based on the vendor you're utilizing to disclose the use of that vendor in your website privacy policy. Google Analytics is a good example of that, where you have an affirmative disclosure by, you, and lots of times, your development team or your web team or, your agency clicks through those terms. You now have legally made a contractual obligation to put a disclosure in your website privacy policy. Super, super important. Um, I think there's a lot here. I think those are my big takeaways.
Those are really good. And when you put it all together, you really need a program. You can't just test all by itself. You can't just have one person do it. It's cross-functional. You need a policy, you need procedures, you need risk assessments, you need a team to be able to build and deploy and continuously test, train new people because you might have trained the first person, now they're off. You need a way to audit and maintain this. So with that being said, we have a handful of questions. I'm going to pick kind of a few of these. Please make sure we all have various resources. Make sure that you are following and you reach out to Kamy and to Taylor and to the Baker team. And so let me tackle some of these questions that are here. Kamy, this one I think is really interesting. Are you seeing AI enabled investigations driving increased litigation or enforcement?
Not AI-enabled investigations, but what I think you will see with the rise of AI is less attorney-focused demand letters and just regular people going into AI. And we see this. This is the uptick has in the last 6 months has been huge. They just go into AI and say, draft me a demand letter to such and such company for violating my privacy rights. Um, so that has been, I think, is going to continue to grow. You're getting people, posting on Reddit. Yeah, just go to AI, go to use the AI and draft a letter and send it, and you can demand X amount of dollars for SIPA claims. So those have been starting to grow, um, and I think they're only going to grow with the rise of AI and everyone using AI. So um, that's unfortunate, but I think there'll be ways to prevent that in the future. But right now, those are concerning.
That is fascinating. So I think for our last question, Taylor, I'm going to throw this one to you. And this gets to the account level opt-out. When a user is logged in and has made a choice to reject marketing cookies, should this be opted out across cross domains or at an account level?
It depends on how your business is structured. So if those cross domains, you're one business and you're commonly branded and under common corporate control, and the consumer would reasonably understand that they're interacting with one entity, then you do need to respect it across domains. If you recognize who that user is too. So sometimes there's limitations, like you don't know who that person is because they're not logged in and all you have is a random IP address. But if you're able to recognize someone, then yes. But it also, there's many other considerations there. It comes into, your corporate structure. Are you separate and distinct brands? Do you share data between your brands so that you take the posture you're one company and thus sharing data between brands isn't a sale? There's a lot of different considerations there.
Thank you so much. So there's one other question I think we can kind of quickly answer it, which is there a cookie digital tracking database to look up how cookies should be classified, knowing that there isn't a one size fits all? I mean, I've seen a few different ones online, but I would caution only relying on that. It really goes to how you, the company, are using that cookie. And it goes to the contract and everything that Taylor was talking about, as well as Kamy. And I see them nodding their heads. So you can if you have no idea what the purple company is, you could go and get, oh, this is a typically that kind of cookie, and that might give you a sense. I would not rely on that classification. You're going to need to peel back the layers of that onion and keep asking the questions of what is actually happening and tie it back to the contract that you have in place. So with that, Taylor and Kami, I want to say thank you so much. We really could have probably spent an entire day talking about this. There is so much here to uncover. We're really grateful that you came. Thank you to everyone who participated. And if you have any additional questions, please contact Kami and Taylor. They are true experts in the field.
Thank
Thank
you
you,
for having
Jodi.
us, Jody.
Thank you. Bye bye.
Bye all.